Well, hello, and welcome to topic number 3 in Real Estate 617, the Law of Common Interest Communities. Today, we're going to talk about association functions and powers. And among other things, we are going to go through many of the provisions of the Illinois Condominium Property Act, where you find a lot of these functions and powers laid out. And you should understand that we can't cover this whole topic in one session, that a number of our sessions to follow will actually be about specific aspects of association functions and powers. And so, but this is the important overview where you get the big picture of this. So be patient and we'll just go through this. First, let's talk briefly about the statutory law framework that we have to work with here. First is the Illinois Condominium Property Act, and that is what I'm going to go through with you today in some detail. And the citation is there on your slide. Second is the Illinois Common Interest Community Associations Act, which covers homeowner associations, in other words, non-condominium community associations. Now, I'm not going to go through that one in the same detail. It's shorter, it's similar, it has similar provisions in it. It is essentially a stripped down version of the Condo Act made more applicable to non-condo associations. Some people think that it really was drafted too hastily and not given sufficient thought. But in any event, I think you'll get the basics. There's more detail in the Condo Act. And so I think it'll be adequately covered. The basic concepts will be covered. But understand, if you're dealing with a non-condo act, you want to check the Community Associations Act, and that citation is there as well. Third, there's another piece of legislation called the Illinois Condominium and Common Interest Community Ombudsperson Act. I was involved in drafting part of that act and parts of that act. It is not really fully operational yet because of the funding situation in the state legislature. And now you have a little screen cap over to the right in this slide where you can see that you can't even call the ombudsperson. There is a person in this position. She is an already existing state employee. You can send them emails, but they haven't really started functioning in a big way. There are no reports yet on their activities, and there are condominium ombuds people in a number of states, in Virginia, Florida, Nevada, and in those states they do annual reports where they tell you about what they've done. There's no report available yet, no real information available. So the condominium ombudsperson is intended to help facilitate alternative dispute resolution and keep track of activities, do some educational activities, but really this has not gotten going yet. So we shall see what happens with that. The Illinois Code of Civil Procedure sections pertain to forcible entry and detainer. As I said in previous presentation, in Illinois, condo associations and HOAs can collect overdue assessments using the landlord-tenant provisions of forcible entry and detainer, which is much faster than foreclosure. Associations can still use foreclosure, but they don't have to. They have an alternative approach, so that's what that's about. We're going to make some reference to that as well. Now let's just talk a little bit about why the powers of the association exist, what they are for. First, a lot of the powers of the associations that you find in their declaration and other documents and the statutes are intended to carry out the developer's original plan to build out and sell the project. And there's this period of developer control that we're going to talk about in a minute, that where the developers are given special abilities to do that, to sell the project out, get it rolling. And during that time, there's really the emphasis is often on rigidity. That is, developers want everything to be uniform because they want the project to be easy to sell. They don't want a lot of individualization of lots of the people who live there. They want things to look the same. They want it to look like it's a big store, in a sense. The second reason is to maintain the common elements of the property forever. That is the ultimate purpose of an association, to maintain the common elements of the property and to safeguard the property values in the community. This then is expanded in most declarations to include more general statements about addressing the needs of the community in terms of quality of life. And so this is where you find it's not exactly implied powers, but it's a broader concept of what the association is for, where you need a little flexibility. The document amendment provisions allow for responsiveness to the needs and the changing needs of the people. And you might say there's a bit of a democratic principle at work here, although associations are not terribly democratic, but they are to a limited extent. And the idea is a certain amount of flexibility and responsiveness once the association is turned over to owner control. And lastly, you will see that associations carry out some functions that are very similar to local government functions, things that actually are, you might say, have been informally delegated to them by local government, where they're taking care of streets and roads and using kind of a police power sort of a thing to regulate behavior. Understand they're not a government, but sometimes the courts seem to treat them as if they were. And so I'm going to talk a little bit about that at the very end of the presentation. So let's talk about the developer control and phase. For the first few years of a project's life, the declarant, that is the developer, controls the association. The declaration has provisions in it that guarantee that the developer will stay in control during that period. And during that period, the developer has certain special powers or developer rights that the association will not have once the owners take control. And these developer rights are designed to help the developer sell out so the project doesn't fail. If the units do not sell out fast enough, the developer, the original developer, may get into financial difficulty. They may not be able to pay back their loans to the banks that funded the construction of the project. And this happened to a lot of developers in 2007, 2008. I mean, there were projects failing all over the country. Newman Homes, for example, a substantial developer in the Midwest, they went bankrupt and shut down, just abandoned construction of numerous projects, including one in Antioch in Lake County that was just left unfinished. It really caused a lot of problems. Well, if the original developer has to sell because they can't handle it any longer, or if they are essentially foreclosed on their construction loan, an issue can arise concerning whether or not the subsequent owner of the developer's interest retains the developer's rights or not. And so that's something that you have to look at if you ever represent a developer or a successor in interest to a developer. So what are these developer rights? And these should be in the declaration, and they are in most declarations that are well drafted. Sometimes they're not, but they should be. And by the way, if you want to talk to an attorney or consult with an attorney who really knows a lot about this, that would be Brian Meltzer. That's Meltzer at Meltzer, Pertil and Stelly in downtown Chicago. He's one of the best of developer attorneys. Has frequently spoken at this course for me, and is a tremendous resource on this topic. But anyway. These rights should be reserved to the developer in the declaration, and they are normally written in such a way that they are not subject to amendment except by the declarant. This is part of the special rights. That is, the developer's rights are protected from the amendment process, in essence. So what are they? 1, the right to maintain model units, signs, other advertising and sales materials on the property, and that might include the right to use one property, that is one association's property, to sell units in other properties that are owned by the developer. Also, the right that prospective buyers and it says lessees and lessors should be able to enter the property and park for free. The right to sell to any buyer the developer chooses with no right of approval or anything of that sort by the association, no first refusal, nothing. The right to build improvements on the property and to store construction equipment on the property. The right to control the association for up to 3 years. And I'm going to show you the section that's involved here in a minute, but that's what it will say. And this is controversial but necessary from a developer standpoint. The right to amend the documents unilaterally if necessary in order to comply with laws and changes in the laws, to correct errors and omissions, and to comply with the requirements of the secondary mortgage market. So let's say that Fannie Mae changes some rule or requirement, the developer will unilaterally amend the documents so that the documents comply with Fannie Mae's requirements. And this is the important part. All these rights need to be assignable. That is, the developer needs to state in the declaration that they retain the right to assign these rights to somebody else, so that if they have to sell out or if they get foreclosed on, whoever becomes the developer's successor in interest gets the developer rights. Now, the reason this is important is because it's really probably in nobody's interest for sales to stall, for the project to get stuck, 65% sold or 50% sold or something. And so these rights are designed really to get the project units. Now, there's another developer rights provision that you might see, and this is controversial, and that would be a provision that discourages the association from suing the developer after association takeover. And it would be this is not a part of the this is not something that fades away after 3 years. This is a provision that would be a permanent part of the declaration, and this is being done in a number of states. You'll see this. So let's say the association contacts you about possibly filing a construction defect case, or potentially a lawsuit against the developer for breach of fiduciary duty for underfunding the reserve funds or something of that sort, but put the association in a bad financial place. Well, this is what you might see. You might see a provision that requires a supermajority vote of association members in order to authorize the board to file a lawsuit against the developer. So what they're preventing here is the board on their own simply deciding to file a lawsuit. And that is the way it usually would work. The board just makes a decision. They don't have to put it to a vote. Well, you might see in the declaration a requirement of a supermajority vote of association members. You might also see provisions requiring that the association give the developer a chance to repair the property, a good faith repair provision that must be undertaken before they file a lawsuit. So the association must let the developer try to fix the defects. And third, you may see a provision requiring mandatory arbitration. That, in other words, which may be binding or non-binding. It may be written up in different ways. But the point is, this really strips away the association's ability to file a lawsuit. You can expect litigation sometimes over these things, and this goes on all over the country. There have been many attempts to do this. The Supreme Court, the U.S. Supreme Court, has been generally supportive of mandatory arbitration agreements between consumers and businesses. So stay tuned. This is an issue to be aware of. And then before we get into the specific provisions, understand where a lot of this came from. The functions of associations have sort of grown over time. They've taken on more and more responsibilities. When they first came into existence, and I'm talking now about HOAs because remember there weren't any condos in the 19th century. Originally, the first associations just had really one purpose, which was to manage commonly held open space. So you'd have a nice group of homes around a village green type of thing that was only to be used by the people who fronted on it, and then the whole thing was enclosed. The houses had a fence around them and everything. So you have a little garden community, and all the association really needed to do was collect some money to mow the grass and maintain the open space. It was pretty simple. But in the early 20th century, with Jesse Clyde Nichols and other people began to have expanded views of what associations could do. And they're putting out in suburban and exurban areas where there wasn't even an incorporated municipality. So then they're managing common resources. Then they started taking on responsibilities, budgeting, assessment, spending. So the associations had to become a little bit more like businesses. And they kind of had a focus on protecting and maximizing property values. But then again, that's a little more expanded than the original function of just taking care of open space. Late 20th century, 70s, 80s, 90s, and on, well, now we start seeing associations getting involved in regulating conduct. And this is because a lot of the things people are doing in their subdivisions may affect property values. You may be on your own property, but you might do something that affects the property values and the lifestyle of other people. Parking, and this is where a lot of the cases have come from. You may have heard about parking pickup trucks in the garages and in the driveways, and parking on the street in front of your home, and different types of fences, and satellite dishes, particularly in the old days when they were big, and ham radio antennas, and elaborate playgrounds, and big Christmas trees and light displays and Halloween display, all this type of stuff, flags and whatnot. And you know about all the litigation. You've read about it, I'm sure, that this happens all the time. This is associations getting in trouble, in a sense, in conflict, I should say, because they're engaging in sort of quasi-government type activities. And this expands their activities beyond what they were doing in the past, but they're doing it. And it's controversial. And now, in the 21st century, we are starting to see a move in the industry to draft declarations that encourage associations to take on what we call community building functions, to try to encourage social activity among the residents, to get them to enjoy themselves. And this is because it is believed in the industry that homeowners, home buyers, have a greater interest in a sense of community than they used to. They don't want to just be an island unto themselves. They want to know their neighbors, and they like living in a place that facilitates a sense of community. So that's where things are headed. So where do all these powers come from? Well, we've covered this, but let's just touch on it one more time as a reminder. They come from state statutory law governing not-for-profit corporations. I went through the statutes at the beginning of this presentation. And the specific ones that cover condos and HOAs. So you have for example, in Illinois, the Not-for-Profit Corporation Act, you have the Condo Act, the Common Interest Community Association Act, the Ombudsman Act, and the Code of Civil Procedure. Then we have case law, lots of it. We'll talk about, some of it, but there's a huge volume of it. And then the express terms of the governing documents, the declaration, the articles, the bylaws, the rules and regs. And then potentially implied powers drawn from general terms in the governing documents, where you'll see references to protection of property values, protecting the quality of life. Sometimes those things become a source of power for association actions as well. Now, we covered this again on judicial review. Just recall that over time, the Illinois courts have tended to move somewhat away from the natural rights position, natural property rights, protecting the natural rights of the property owner against intrusion by these agreements. They've moved away from that, along with the rest of U.S. courts, toward finding that covenants are almost always enforceable, as long as they are not arbitrary, illegal, or violate a fundamental public policy. Now, the general rule is these covenants and board actions are scrutinized in light of a strict interpretation of the covenants. But what does that mean? Focus on the words, understood in the context of the whole document, and considering the apparent intent of the parties. So that's just something to keep in mind as a general way of understanding how these various provisions that we're going to talk about are applied. So this is what we see, the kind of functions that the Act covers and that associations engage in. Managing the common area or property, repairs, maintenance, maybe improvements, changing landscaping and things of that sort, putting up walls, taking them down. Issues of association access to individual units for repair, for inspection, and then if there's discovery in a lawsuit, you can bet that people will be inside the units. Sometimes acquisition of property, sometimes associations acquire property, not often, but it does happen. Rule making and regulation, that is, when they make their rules, when they amend their documents, when they try to regulate behavior. And then often they're in a conflict resolution mode, resolving issues concerning competing interests, competing actions within the development, especially in the common area, such as disputes over parking, who gets what parking space, who has to pay for what. Dogs, pets are a very common source of conflict. And often associations have to resolve disputes and make rules concerning pets, such as dogs. And in urban condo buildings, dog walkers come into the building to walk people's dogs during the day. This can be a source of enormous conflict. and the dogs get into conflict with each other, the owners get into conflict with the dog walkers. These things can happen. And then lastly, political and legal advocacy. Sometimes the association may want to get involved in a NIMBY, not in my backyard type issue with adjacent property. They may want to have the association president or board speak out on some issue that might affect them. Why, if they build the high-rise next door, it'll affect us in the following way. And often legal advocacy, construction defects. The association is empowered to act on behalf of the members on matters concerning the units, all the units, and such as construction defects. And so this is, in some states, not so much Illinois, but in many states, this is a huge business for attorneys and construction defect lawsuits for condo. So here we go. Let's begin by going into the provisions, the most important provisions at least, of the Illinois Condo Act. I'm going to go through the act and tell you what they're about, and then hit on a number of them that I think are particularly important. So we start with, and you have the act in your materials, so you can go through it. So section 1 is just the title. Section 2 talks about definitions, and it defines all these words like what is the declaration, what are the common elements, which would be all the portions of the property except the units, including limited common elements. It describes what does majority mean, where the word majority is used. It means the owners of more than 50% in the aggregate in interest of the undivided ownership of the common element, etc. So you find all these definitions, and there are many of them. It goes up through Z, and so there are about 26 definitions in there about the period of developer control, etc., etc. So that's what's there. 2.1 applicability. It applies to all condominiums in the state, and it says that any provision, this is in 2.1, any provision in a condo instrument that is inconsistent with the provisions of the Act are void as against public policy and are ineffective. So condo decks cannot supersede the statute. Section 3 is about submission of the property. Now, this refers to the declaration stating that the property, the condominium property, is submitted to the provisions of the Condo Act. That must be done in a recorded declaration. So you'll always see that in a condo declaration, that it is submitted to the provisions of the Condo Act. Section 4 talks about what must be in the declaration, and it goes on to list a whole bunch of provisions that must be in the declaration that you will see in every single condo declaration. The legal description, the name, the location, description of the common elements, the limited common elements, the date of recording, etc., etc. These things all must be in the declaration, and it'll talk about, it specifies exactly what must be there, but you'll see almost all declarations contain basically these same essential elements. Now, section 4.1, this is about the construction, interpretation, and validity of the instruments. This is where it explains that, for example, how do we precisely delineate between the airspace and the in a condominium, the unit, the individual interest, the airspace, and the common elements. So this is where it says in subparagraph 2, for example, how precisely to do that. Decorating, wall and floor coverings, paneling, these things are part of the unit, while all other provisions of the floors, etc., are part of the common elements. So it explains about chutes and conduits and wires and so forth like that. That portions, if the pipe is partially within and partially outside the boundaries of a unit, any portion of it serving only that unit is part of the unit, while any portion thereof serving more than one unit is part of the common elements, and on and on. So these are how in other words, how we interpret the specific words that are in all these documents. That certain things are limited common elements, such as shutters, awnings, window boxes, door steps, etc. They are deemed limited common elements. So things of this sort, and these are important definitions. Now, section 5 talks about recording the plat. I'm not going to go through a lot of details on that. It's simply for the developer to be concerned how they do that. Then section 6 is about recording, and meaning that upon recording of the declaration in the plat, the property becomes subject to the provisions of the act. And this is the point at which sales can commence. It also explains that there's something called, that I'll hit on again, called add-on condominiums. Developers are allowed to put in the declaration a provision that they can add on other phases, other units to the condominium declaration during the period that they control it. And so that has special recording requirements as well. Section 7, descriptions in deeds. That's something we don't need to worry too much about. Section 8, partition of the common elements is prohibited. As long as the project is subject to the provisions of the Act, you cannot partition or divide the common elements. This is because, remember, the people who own these units in a condo project are basically tenants in common, but the association doesn't have the power to partition out the common elements to the various owners unless they dissolve the association, which is possible. That can be done under special circumstances. Section 9, sharing of expenses and lien for non-payment of reserves. All common expenses accrued prior to the first conveyance have to be paid by the developer. But after the things are sold, then what the point of this section is that common expenses are the obligation of the owners. And it explains that they're entitled to an annual budget, a detailed proposed annual budget that explains all the expenses, and that it provides for, there must be a provision for reasonable reserves for capital expenditures and deferred maintenance of the common elements. All right, this is an important provision. That is, associations are required in setting their assessments to not just pay the monthly expenses, but set aside an amount for reasonable reserves. But guess what? It doesn't say how much reasonable reserves are. And this is a real problem because many associations are in fact under-reserved. And so when they don't even do reserve studies. In some states, the associations are required to do reserve studies like every 3 years, or do some kind of a reserve study even every year in a few states. In Illinois, they're not required to do a reserve study at all. Reserve study should ideally be done by a professional, but it could even be done by the association board of directors, potentially. That's not ideal, but it could be done. Well, in Illinois, all they have to do is have reasonable reserves. They can waive, in fact, subparagraph C says they can waive in whole or in part the reserve requirement by a vote of 2/3 of the total votes of the association. So that is really troubling. And if you're thinking about buying a condo, you ought to take a look at what they have in reserve, because lack of reserves can lead to massive special assessments. And I know of many situations where lack of reserves led to $20,000, $30,000, $40,000, $50,000 special assessments. So, that's buyer beware, and a lawyer should advise people of it as well. Now, also the lien provision, that means that if the owner doesn't make a payment on their assessment, if they miss a payment, if they miss several payments, those payments become a lien on the interest of the unit owner on the property, and it can be foreclosed on. So that's why I said earlier that associations have a lien, and also they have a lien for collecting not only the unpaid assessments, but they can also collect interest, late charges, reasonable attorney fees, and this all becomes a part of the lien. And so often it can happen that the judgment by the association for unpaid assessments, you could have $500 in unpaid assessments. The collection cost might be $5,000, but the owner has to satisfy and pay all those costs in order to extinguish the lien. So this is serious business. Now this section goes on to provide what happens in case of foreclosure, etc. I'm not going to go through all the details of this, but it is a very detailed section. Read this if you're interested in learning more about how these assessments are allocated, and they're on a percentage basis. That is, your percentage of the assessment bill is the same as your percentage of ownership for your condo unit. But in terms of non-payment, this is a critical issue in difficult economic times. We see a lot of foreclosures, and so that becomes big business for association lawyers. 9.1, other liens. Now this refers to other types of liens, and as it explains, they ordinarily liens, like for work, let's say someone has work done on their unit, the mechanic attaches the lien if a payment is delinquent. The lien goes against the person's individual interest, not against the common elements. There are more complicated situations where the association enters into a contract, but this is a very difficult situation that can create a lot of unpleasantness. Because the reason it can cause problems is because if the association authorizes work to be done and then doesn't pay, each unit owner is deemed to have authorized the work and consented to it. And so the lien does not go against the common elements. The lien goes against the units, the owner's units. And which ultimately, if you think about it, really adds up to the value of the entire project. Because the units, each owner is, because they're a tenant in common, if you added up the net value of all the individual interests, you have the sum total of the property. So in any event, this can be a very messy situation if the board authorizes it, because the individual owners can find themselves subject to these liens. Now, section 9.2, very important. This is the one that authorizes forcible detainer. This is the one that explains that if you do not pay your assessments, the board of managers or etc. can haul you into housing court and basically evict you from your own unit and obtain all the the attorney's fees, etc. that go with evicting you. So as I said, this is an advantage for Illinois condos in associations, in the sense that it is an additional tool for collecting assessments that often gets a quick response. I've missed one here. There's a 9.5 that somehow is omitted here. It simply states that if the developer assigns their interest in the property, remember I mentioned that in a case of a project that's in trouble, developers may assign their interest in the property. It is not effective unless the assignment is in writing and recorded. You would probably imagine that it would be the case in any event. Real estate taxes are assessed upon each unit in the owner's corresponding percentage of ownership in the common elements. So that's what I meant by saying that you get the sum total dollar value of the property if you added up all the individual units. So in essence, your right to use the common elements and your percentage ownership in it is assigned in essence to your unit, as opposed to a separate property tax bill going to the association. Tax deeds, section 11. This basically says that if anyone acquires a tax deed to any of the condo property, that the interest is subject to all the provisions of the Condo Act. Now, section 12 in insurance, we're going to do a whole section on insurance. This is very important, very, very important. Lawyers need to understand how this works. There are required coverages. We're going to talk about it at length, but understand there are specific provisions in the Condo Act about what type of insurance associations must get. They must have property insurance, that is, first-party property insurance to insure the property itself. They must get liability insurance, that is third-party coverage, that insures the association against getting sued because someone gets hurt on the property. So you have first party, you have third party. They must get a fidelity bond and directors and officers coverage if they have more than 6 units. That is to protect them against fraud, theft, etc. by their own directors. And believe me, directors, employees, and officers, this happens. This absolutely happens. Property managers have many, many cases of property managers embezzling funds, presidents of associations, treasurers, embezzling funds. I have a notebook 3 inches thick full of newspaper clippings where this has happened. It happens with a good degree of regularity. It has to be watched for. So, and we're gonna go through the whole all the insurance provisions. It's quite detailed what they have to have, and so as the attorney, need to make sure that they do it. There's also 12.1 insurance risk pooling trust. I have never been involved in this, but 2 or more condo associations or common interest community associations can create a trust fund and pool their insurance needs. Now, one place you might want to be on the alert here is there is at least one very large property management firm. In other words, a firm that works for associations and manages their property, etc., that carries its own insurance. They have their own insurance company. They have their own bank, etc. And you need to look at this very closely if you're involved with this, because you could get in a position where if the association fires the property manager, they lose their insurance. And you have to be really, really careful about this, so that you don't have a contract with a property manager that says, well, if you fire us, you automatically lose your insurance. That could cause problems. It could cause a lapse in coverage. You could also lose your banking, lose your bank at the same time you lose your property manager. So you need to watch this. I personally don't really like contracts, property management contracts like that, but there are some associations that like it. Section 13, application of insurance proceeds to reconstruction. If there's a fire or another disaster and the building, and it's enough to reconstruct the building, it has to be reconstructed. That means restoring it to substantially the same condition in which it existed prior to the fire, with the same boundaries, if there's enough money to do that. Now, if they're insufficient, that's where we go to 14. If they're insufficient, that is, the place burns down, it can't be rebuilt, you don't have enough money to do it, it explains what happens here. And how you deal with an action for partition, for splitting it up and so forth. So that's what that section's about. That's a rare occurrence, but you can read it if that interests you. Disposition or removal of any portion of the property, 14.1. This, again, is about withdrawing property from the condominium, and it explains how that is done, and what you do with the percentage allocations, that if certain property is removed, remember, everyone is a percentage owner of the whole building, except for their individual units, and so you have to recalculate the percentages. 14.2, street and utility dedication. This is where you have, for example, a private street in a condo association, or private sewer, private water, and you want to dedicate it to the public so that it will become the responsibility and the property of a governmental agency, like a city or county or water district or something. So it provides that can be done. It takes a 2/3 majority of the unit owners to do that. 14.3, easements for laying cable or high-speed internet. It takes a majority of 50% of the unit owners to authorize that. 14.4, water damage is a similar type thing, 50% vote. Now, 14.5, I have not listed 14.5 here. There is a 14.5. That is called the Distressed Condominium Property Act, and I'm going to talk about that with you when we discuss financing. So I'm not going to go into it here, but 14.5 is a relatively new provision of law that provides for what can be done with a property, a failing condominium project that has serious problems. And it's called the Distressed Condominium Property Act. We will go over that in considerable detail. How that all works. Basically, it involves the appointment of a receiver and turning the condominium into an apartment building. But we'll go over that. Section 15 talks about sale of the property. This is something that happens to distressed properties normally, and it takes unless if it's more than 2 units, which almost all condos are, it takes 2/3 vote, and if it's over more than 4 units, it takes at least 75% vote to sell the property. Now, when would that happen? That happens with failed condo associations, just like I said in 14.5, Distressed Condo Act. Okay, sometimes there are properties that are just failing, and a syndicate of real estate buyers or somebody comes in and buys 3/4 or more of the units, and they can sell the property at that point. And that's when you see these projects being removed from the act. So let's go to 16. That's what happens where, in this case, all the owners may remove the property from the provisions of the act by an instrument to that effect. And at that point, it turns into a tenancy in common. But often what these real estate developers do is they want to come in and turn it into, once it's a tenancy in common, turn it into an apartment. Let me back up here. Section 18.8 that basically allows the association to use electronic technology for communicating with the members. That's a relatively new provision. Section 19, records of the association have to be made available to the members under certain conditions. This is a source of enormous dispute, people wanting to see the records and which records. So certain things are mandatory disclosure, such as the governing documents, the rules, etc. The articles of incorporation, basic contracts and leases. And so these things must be produced, and there actually are penalties for failing to produce them. So you can read the details of how this works. Section 20, this is an exemption from the rule against perpetuities. You may remember that, the rule against perpetuities from law school. So condominiums are exempt from that. They are also exempt from the rule that says there can be no unreasonable restraints on alienation. So you cannot sue to invalidate a restriction on the grounds that it violates the rule against perpetuities or the rule against restraints on alienation. So you can remember those things. Remember those things you learned in law school? You can forget about them where the condos are concerned because they don't apply. Severability, well, that's in every contract and provision. If one is invalid, the others, if any provision of an act is declared invalid, the others remain in force. Section 22, very important. These 22 sections are very important because these pertain to disclosure. If you have a sale, in the initial sale, this is Section 22 is for initial sales by the developer. The developer has to disclose governing documents, etc., floor plans, condominium fee amounts, and all sorts of other information. This is what the developer has to disclose to purchasers. In resales, that's 22.1. The condo association is required to make available for inspection to prospective purchaser upon demand. So if you're representing a buyer, you have to ask for this under 22.1 from the association. You don't just get disclosure from the seller, you get disclosure from the association, and under 22.1. And again, you get all the decks. You can find out about a statement of and status of the amount of reserves that they have available, the statement of financial condition, insurance coverage, etc. And you need to find out from the association and from the seller whether or not any special assessment is pending or expected, because you don't want to have your buyer acquire the unit and then get hit with a $50,000 special assessment 3 months later. 22.2 resale approval. That says basically, so the condo association may not exercise a right of refusal on the basis that the purchaser's financing is guaranteed by the FHA. 23, encroachments. This explains what happens if you have the common elements encroaching upon a unit. 24, this deals with deposits. This is about initial sales. Again, this pertains to developers, so I'll pass over that. 25 is what I mentioned earlier, add-on condos. The developer can reserve the right, and they will do this in the declaration, to add on property to the property that has already been submitted to the act. So they can make the project bigger. Now, often existing owners are furious about this, but the developers reserve the right to do that, and it says in this section exactly how they do it, and all developer attorneys know how to do this. They can do it for up to 10 years from the date of the recording of the declaration, and so this can be a source of great anger, but if it's done properly, they can do it. Transfer of limited common elements 26. This means basically that owners can transfer the use of limited common elements between themselves at their expense. This is a rare occurrence, but this might happen with respect to parking spots if they're limited common elements. Parking spots could be limited common elements. They could also be separately deeded parcels of property, or they could simply be parts of the common elements that are allocated at the board's discretion. Boy, is this a source of conflict. 27, amendment of the condo instruments. This basically provides that either that you can't have greater than a 2/3 voting requirement for amending the condo instruments. It might be less than that in the deck, but you can't go over 2/3. Or 3/4 under certain conditions. So and then there also are provisions for mortgagee consent. Then there's a provision for scrivener's errors. That is just a scrivener's error is an error by the people who drew up the documents. And we're going to talk, when we talk about amendments, this is section 27, we're going to cover amendments in one whole section. So, but briefly, you can read this if you want, but we're going to cover it. 29, alterations within adjoining units. If a unit owner owns 2 or more units, they can remove the partition as long as it doesn't impair the building, the structural integrity of the building. Condominium conversions, 30 and 30.5. This provides how that's done, how apartment buildings are going to be converted to condominiums. That's something there was an awful lot of that done, as you know. And then subdivision or combination of units, unless it is prohibited, this is 31, unless it is prohibited, the owners can subdivide or combine common elements. Again, this is a process that can occasionally happen. I think it's something that you see with certain types of facilities. 32, alternative dispute resolution, mediation and arbitration. The declarations or the bylaws may require mediation or arbitration of disputes if the matter in question is $10,000 or less. However, you can't be forced to mediate assessment collection or declaration rules violations, but certain disputes can be, the documents can provide for mandatory mediation or arbitration, and it explains how that works. And lastly, compliance with the Condominium and Common Interest Community Ombudsperson Act. Well, every association must comply with this act, but it is subject to repeal. Understand the act has really not come into full swing, but because of the financial issues that the state's been facing. But it has a sunset clause in it. Now, a sunset clause is a law that a provision that you frequently see with the creation of a new agency that says that unless it is renewed, it goes out of existence at a certain date. Well, the ombudsperson law in its entirety, it will be repealed on July 1st, 2022, unless it is renewed. So we have about 5 years as of this writing, as of saying, I'm saying this in 2017, it may go out of existence or it may get renewed. But again, because of the funding situation, it's not really doing much at the moment. A couple of things I just want to underline. Section 9.1b. Again, the Board of Managers has the standing to act in a representative capacity in relation to matters involving the common elements of more than one unit or more than one unit on behalf of the unit owners. this is important. This used to be disputed, but the board can go out and hire a lawyer and sue, and they can make the decision. It's very important because it makes condo associations it makes it easy for them to sue. They can make the decision themselves. Often they put these things to a vote, but they can just go do it themselves unless the deck provides other remedies. This is the reference to forcible detainer. Section 9.2, we covered this. Understand that this pertains to the condo board collecting overdue assessments and charges, etc., using the forcible detainer. Again, I mentioned eminent domain. We covered this already, but just emphasize it. The unit owners association has to be named as a defendant, and they can act on behalf of the owners. This is interesting. This is section 18A, subsection 8. It's complicated. It's about budgets and assessments, so I wanted to just summarize it on a slide here. This is what it says. It takes forever to say this. If the budget or the assessment is over 115%, that is a budget or a special assessment, is over 115% of the previous year, then owners with 20% of the votes can petition within 14 days of the board action on this assessment. Let's say they increase the assessments by, add by 50% over last year. So this year's assessment is more than 115% of last year's. It's 150%. All right, if that happens, then 20% of the unit ownership can petition. They have 14 days to do the petition. They petition for a meeting of the owners, which must take place within 30 days of the petition. Well, at that meeting, if a majority of the total ownership votes, not those who show up, of all ownership votes, 50%, more than 50% of the ownership votes can vote against the increase. If they vote against the increase, then it's canceled. But if you have a situation where you get 49.8% of the total ownership, then the board's action in raising the assessments is ratified. So basically, it's a protection against it. It's a fail-safe, but it's a check on a board that imposes excessive assessments, excessive or a huge budget increase, and so it gives 1/5 of the owners can petition for a meeting, and at that meeting, it's possible for a majority of the ownership votes to veto the increase. But understand, getting a majority of the total ownership votes for anything is really tough because many people don't vote at all. So that complicates the process of getting a majority of all total ownership. 18.3, where it talks, we covered this, but again, this is just to underline certain important provisions. The Unit Owners Association is responsible for the administration of the property. They have all the powers of the General Not-for-Profit Corporation Act unless they're inconsistent with the Act or unless they're inconsistent with the condo instruments. They can acquire land, etc., and they can, as I said, do anything necessary or convenient to carry out the purposes for which they were organized, as long as it's not against the law. Again, this is the section 18.4 that talks about the powers of the Board of Managers. We've gone through. I'm going to let you take a look at that at your leisure, but as you can see, it's quite an expansive grant of specific. Let me just emphasize one more time that the officers and the members of the board are fiduciaries. This is very serious business and can lead to charges of breach of fiduciary duty. So always keep that in mind when you're advising a board. This 18.5, again, what we have here is that the common interest community associations, I didn't mention this before, but common interest community associations can also use forcible detainer, not just condos. Even though it's in the Condo Act, it's also very clear that HOAs can do the same. Easily, if it is pertinent. 735 Illinois compiled statutes, as you can see, the section 5/9-102. Now, let me just take a couple of minutes at the very end of this presentation to talk a bit about one issue that is of governance, and that is, are there any times when the community association is viewed as essentially like a mini government? We're going to cover this in more detail, but just to put this in a broad outline, there are basically three ways to review the standards, to review the actions of a board of directors of an association. Three standards. One is the business judgment rule. And the business judgment rule is a standard basically of judicial deference. When the board is making a routine business decision, about how do you, property, finances, budgeting, this sort of thing, normally the rule they use is the business judgment rule, which basically says, in large part, judges presume the decision is valid unless there's something wrong with the way it was made. If it looks like there's self-dealing, if it looks like the board didn't inform itself at all, they look at the procedure. They look at the way it was decided, the decision was made, and it looks like a routine business judgment made with their eyes open and no self-dealing, no conflicts of interest. Normally, the judge will not remake the decision and ask whether it was reasonable or not. But if they think there's something wrong with it, maybe there was potential self-dealing, then the judge may look at the merits of the decision and try to see if it was reasonable. The rule of reason is reasonableness of decisions usually applies to behavioral rules. Is this rule a reasonable rule? Or was this rule applied reasonably in the given situation? And this is where judges get into the merits of the decision. And this is a quagmire that judges do not want to get into, remaking all the decisions about whether to, how to do the termite inspection or what should the pool rules be. I mean, you can imagine circuit court judges just are not interested in this. Was that party too loud or not? For God's sake, I mean, so the business judgment rule, you should always be prepared to view the business judgment rule as the floor. There are times, however, when the reasonableness of the decision may come into play. And then on a rare occurrence, this is not really the case in Illinois, but in some states this has happened. There are some situations where courts have looked at associations almost as if they were governments. And this is where they get involved, for example, in running elections. There are many situations where you might have a voting precinct in the association on the association property. Well, you might find yourself being looked at in terms of whether there was discrimination, whether there was denial of due process of law. These are weird situations, and there are other such things that happen. So just really quickly, there are different theories for applying the doctrine of state action, for saying that a private entity was actually carrying out state action. One is where they're enforcing race-restrictive covenants that ban the ownership or sale of property to people of who are African American or of a particular religion, whatever the excluded category is. In that case, judicial enforcement of the private covenant is deemed to be state action. Then there's the symbiotic relationship theory, where you have government working in league with private entities and violating people's constitutional rights. And then the public function test. Famous case, Marsh versus Alabama from the late 1940s. Can a homeowner association that has all the attributes of a municipality be held to the standards of being a municipality? And that's kind of what happened in Marsh versus Alabama, not with an HOA, but with a company town called Chickasaw, Alabama. So these are things just to be aware of. The arguments do get made from time to time, and we shall see what happens in the future with this. The Supreme Court has been reluctant to go there in recent years, but you never know. State courts in New Jersey have been willing to consider such things as the public function test and symbiotic relationship test as applied to things like managing elections and so forth. So one never knows.